Case 4. Bailey, the plaintiff, versus Rocky Mountain Holdings, the defendant. We find ourselves in this case, again in the U.S. District Court, this time in the South District of Florida. Let's start with the facts. The facts underlying this action are largely undisputed. The parties agree that Defendant Air Methods Corporation, hereinafter Air Methods, is authorized by the Federal Aviation Act to operate as a Part 135 air carrier, providing on-demand and air ambulance services. Air Methods is registered with the Department of Transportation to operate as a Part 298 air taxi operator, providing on-demand air ambulance services. Pursuant to their Part 135 certificate and their Part 298 registration, Air Methods, doing business in the state of Florida as Rocky Mountain Holdings, is authorized to operate interstate flights as a common carrier for compensation. Air Methods is also authorized by its Part 135 certificate to operate flights in the 48 contiguous states. The DOT has expressly recognized Air Methods as an air carrier that is authorized to provide interstate transportation. As a Part 135 air carrier, Air Methods is pervasively regulated on safety and economic matters by the FAA. On March 17, 2013, plaintiff's son, Lamar Bailey, sustained fatal injuries in a motor vehicle accident in Martin County, Florida. He was ejected from the vehicle and transported by defendants by helicopter from the accident scene to St. Mary's Medical Center in West Palm Beach, Florida. Plaintiff was thereafter invoiced for the air ambulance service provided by defendants in an amount totaling $27,975.90. Defendants also submitted an invoice to State Farm Insurance, the insurer for the motor vehicle involved in the accident. State Farm, pursuant to Florida's Personal Injury Protection Statute, PIP, paid 80% of what it considered to be the allowable amount, or $6,911.54, 200% of the Medicare Part B fee. Thereafter, defendants submitted a claim for payment to Mr. Lamar Bailey's health insurer, Aetna, which was secondary to the PIP coverage. Aetna then paid defendants the sum of $3,681.60. Defendants applied the amounts paid by both State Farm and Aetna to plaintiff's outstanding balance. The law office of Silver & Silver contacted defendants' billing department on more than one occasion regarding the submission of the charges to Mr. Lamar Bailey's primary and secondary insurance. It is disputed whether during these conversations it was ever communicated the plaintiff was represented as to the debt owed to defendants. In any event, plaintiff did not make any payments to defendants, and the remaining balance of $17,382.76 for air ambulance services was ultimately written off as a bad debt. What is the issue then? Does the ADA preempt state consumer protection claims as applied to air ambulance prices? Well, the holding. The court found that each of plaintiff's state and common law claims could only be fairly characterized as directly challenging Air Methods' rates for its air ambulance services. These claims, if permitted to proceed, would naturally affect the provision of defendant services in addition to the prices of and payment for those services. Consequently, the court reasoned, the lawsuit was essentially a state enforcement action having a very strong connection with or reference to a price, route, or service of an air carrier, and was altogether preempted as a matter of law and was barred from proceeding. Let's look into the reasoning behind this holding. Bailey is an especially interesting case because it is one of the rare cases that construes the term rate in the Airline Deregulation Act. It introduces the concept of air ambulance operators and gives you a different kind of airline case to work with. It represents a rare look at reverse preemption, and the fact pattern it presents is increasingly coming before courts around the nation with respect to charges for air ambulance services. Let's start by defining Part 135 carriers and how the FAA certifies such carriers. The FAA's website on the matter provides an extensive introduction to the topic of on-demand operations as follows. The two basic types of certificates that are available to be issued to U.S. applicants are based on what type of services the applicant will be providing and where they want to conduct operations. They are, number one, an air carrier certificate issued to an applicant that will conduct interstate, foreign, or overseas transportation or will carry mail, and two, operating certificate issued to an applicant that will conduct intrastate transportation, which is transportation conducted wholly within the same state in the U.S. Another important consideration when starting the certification process is for the applicant to determine the kind of operations that they wish to conduct. 14 CFR Part 135 certificate holders can conduct either on-demand operations, which may include limited scheduled operations, or two, scheduled commuter operations, which allow unlimited scheduled operations as well as on-demand operations. Each kind of operation, on-demand or commuter, has specific limitations associated with them. These include the number of passenger seats that can be installed on the aircraft, maximum payload limits, and whether turbojet aircraft can be used in that kind of operation. A 14 CFR Part 135 certificate holder has further options depending on the scope of operations they wish to conduct. The scope of operations is authorized by the FAA through the issuance of operations specifications. We call those OPSPECs. The following different scopes of operations are available: 135 single pilot, 135 single pilot in command, 135 basic, and standard Part 135. Now that you understand 14 Part 135, let's look at air taxi operator under 14 CFR Part 298. There is hereby established a classification of air carriers designated as air taxi operators, which directly engage in air transportation of persons or property or mail, or in any combination, and which, number one, do not directly or indirectly utilize large aircraft. 2. Do not hold a certificate of public convenience and necessity and do not engage in scheduled passenger operations. 3. Have and maintain in effect liability insurance coverage in compliance with the requirements. 4. If operating in foreign air transportation or participating in an interline agreement, subscribe to Agreement 18900. And 5, have registered with the Department in accordance with this subpart C of this part. Next to discuss is the term express preemption and what purpose or policy goal does it serve. The Supremacy Clause of the United States Constitution reads as follows: This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. This case is an example of express preemption, which serves to void any state legislation that interferes with the laws of Congress. Under the umbrella of the Supremacy Clause in the U.S. Constitution, the concept of express preemption vests Congress with a dominant power to create laws for the entire nation. Express preemption exists when the language of a federal law communicates an explicit intent by Congress to preempt state law. Whether a federal law preempts a state law is a question of congressional intent. Thus, if Congress intended to govern an issue exclusively, it need only say so, as it has done in various areas. This preemptive power is based on the supremacy clause of the Constitution. In other words, the Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. As interpreted by Chief Justice Marshall, in every case, the act of Congress or the treaty is supreme, and the law of the state, though enacted in the exercise of powers not controverted, must yield to it. The plaintiff in this case claimed that a state insurance law reverse preempts federal domestic commerce legislation. Let's explain. Pursuant to the Airline Deregulation Act, states are expressly prohibited from enacting or enforcing any law, regulation, or other provision which relates to an air carrier's price, route, or service. Notwithstanding the ADA's express preemption provision, plaintiff contended that Florida's PIP statute reverse preempts federal law in this case pursuant to the McCarran-Ferguson Act, MFA. The MFA is a federal statute directed at insulating state insurance regulation from implied preemption by federal domestic commerce legislation. The MFA initially declares that silence on the part of the Congress shall not be construed to impose any barrier to state regulation or taxation of the business of insurance. It further provides that no act of Congress shall be construed to invalidate, impair, or supersede any law enacted by any state for the purpose of regulating the business of insurance, or which imposes a fee or tax upon such business, unless such act specifically relates to the business of insurance. Accordingly, the MFA authorized reverse preemption of federal statutes by state laws enacted to regulate the business of insurance. However, the court found that Congress had not been silent here, and the MFA did not apply to reverse preempt the ADA. In enacting the Airline Deregulation Act, and including in it an express preemption provision, Congress made plain its intent to altogether preempt state laws that regulate an air carrier's prices, routes, or services. The MFA was intended only to protect state insurance regulation from inadvertent intrusion by the federal government, and not to insulate the same from every federal law.